Good afternoon and welcome to today's webinar on Immigration Law Review of the Year webinar, Key Cases and Rule Changes from 2025 with Adam Pipe from No.8 Chambers. Adam is a barrister specialising in immigration, asylum and human rights law and is ranked by Chambers and Partners for immigration law in the Midlands. Adam provides regular updates on the law at training events and on social media. For those who haven't joined our webinars before, my name is Finn and I'm a Junior Compliance Officer at DG Legal. The slides from today's presentation will be sent over tomorrow, and a recording of the webinar will be available for 3 months. So if we run over or you need to leave, you'll be able to watch the rest at a time of your choosing. And also, we are in webinar mode, so we can't see or hear any of you. This is a fast-paced webinar, and I know Adam has a lot to get through, so I'm afraid we won't have time for questions at the end. Over to you, Adam.
Thank you so much, Finn, and thank you everybody for joining today. This is one of my favourite webinars of the year, covering the last year in immigration law in terms of the statement of changes and the recent case law. We've got 738 people signed up today, which is fantastic. There's hundreds of you live online. Great to see some familiar names in the chat. So thank you, everybody. And thank you, DG Legal, for inviting me today. Thank you for Finn for running the event, for George for the technical support, and David for his leadership at DG Legal. If you run a law firm and you're interested in compliance or marketing support, how to handle GDPR or complaints, do reach out to DG, tell them you were on this webinar, and I'm sure they'll be able to give you some support. The link is there. That's the link where the webinar recording will be available and my slides will be available. So do keep an eye out for those tomorrow. DG Legal don't charge for this event. I don't charge for this event. It's completely free. So in order to pay it forward, I'd encourage you to click on that link. And there are 3 charities that DG Legal support. I know some of you have donated in the past, but if everybody donated a couple of quid from those who signed up, we could make a huge positive difference as a result of this webinar. Most of you know me, so I'm not going to bang on about me. What I want to do is give you my resources. So as usual, if you scan this QR code, or if you're old school, just click on the link and that'll take you to my link tree. You'll be able to sign up for my free WhatsApp immigration law channel, or if Telegram is your gig, you can sign up to my Telegram channel. There's access to the YouTube channel, and there's also some details of my free upcoming webinars and in-person seminars. I've got some in-person events coming up in London and Manchester in the spring. In a couple of weeks' time, I'm doing a bespoke webinar on part suitability because there's so much to get through today. At those events, there'll be more chance for questions and discussions. So let's first look. Well, normally over the last couple of years, I've looked at the first half at the statement of changes. Now, the first thing to say is, if I look on my other screen, I've got a list of all the statement of changes. In 2024, there were 4 statement of changes. Unfortunately, in 2025, there were 7 statement of changes. So we've got 7 to get through today, but also we've had 3 major policy papers. So in May, we had Restoring Order and Control, the policy paper that shaped a lot of the changes that came out throughout the year. Then in November, we had the Asylum and Returns Policy Statement. And then also in November, we had the consultation document, A Fairer Pathway to Settlement. So with 7 statements of changes, there are 10 things to go through in this first section. I'll touch upon case law in the second section. So let's dive in and look through another crazy year of immigration law changes. So the first statement of changes was back in March of 2025. Now, one of the themes we've seen over recent years, and we saw again in 2025, was the continual moving of certain countries onto the visa national list. So in this March statement of changes, Trinidad and Tobago were moved. As with all of these changes to people being moved on the visa national list, they usually happen on the day the statement of changes it is laid before Parliament, with usually a 6-week visa-free transition period for those who've already hold an ETA and confirmed bookings. So because of an increase in asylum claims from Trinidad and Tobago, they were added to the visa national list. There were some changes to the Ukraine Permission Extension Scheme. That scheme opened on the 4th of February 2025, and there was a bringing into scope children who'd been granted leave to enter the UK outside of the immigration rules, so they could join or stay with their parents who already held Ukraine scheme permission. I'm not going to go into that. That's there if you want to have a look at it. There were some changes in relation to the EU settlement scheme. There were also changes in relation to care workers. Now, we're going to see as we go through the year, care workers have been targeted. As we look at the case law, we look at the statement of changes, the proposals for settlement, care workers have very much been on the government's radar. The first change that was subsequently revoked because of subsequent changes was this requirement to recruit from the pool of overseas workers already in the United Kingdom. So that was brought in this March statement of changes. There was also a change to the minimum salary for skilled workers. And then there was a removal of the requirement for British nationals overseas to have an electronic travel authorization. So those with BNO passports would no longer need ETAs. One statement of changes done. Let's have a look at the white paper, Restoring Control over the Immigration System. So this was the white paper that really set the direction of travel. And perhaps as I go through it, tick off in your brain what we've already seen brought into force already. So the government's aim was to restore confidence in the immigration system. They want to have the benefits of immigration, but not using it as an alternative to fixing the problems in the UK. Paragraph 27 sets out some of the big changes that were proposed in the white paper. The increase in the skill level for skilled workers, the narrowing of the shortage occupation list onto the temporary shortage list, the closing of the social care visa route to overseas recruitment, restriction of dependence for lower skilled workers, and increases in English language requirements. So I'm just going to highlight these changes, hopefully because of previous webinars I've done, a lot of you are aware of what was set out in the May white paper. So there was an establishment of the Labour Market Evidence Group, or the proposal to establish a Labour Market Evidence Group. And then they want there to be the production of workforce strategies in certain sectors, which will have to be complied with by employers. So paragraph 69 was the proposal to lift the skill level up to RQF6 for skilled workers, and also the increase in salary thresholds. This resulted, paragraph 69, in the reduction of about 180 eligible occupations. Paragraph 70 deals with the immigration salary list going to be abolished, and MAC are going to undertake a review of salary requirements. Well, fast forward to 17th of December 2025, and MAC did do that salary review, and I'll touch upon that later. Paragraph 71, in relation to those who are already utilising the skilled worker visas, from the point that the skills threshold is raised, existing skilled worker visas will continue to be able to renew their visa, change employment, and take supplementary employment in currently eligible occupations below RQF6. However, applicants from overseas or those applying to switch from other routes will have to follow the new rules. Provision then for RQF 3 to 5 skill level jobs, and the time limited basis where MAC has advised it is justified and where there's a workforce strategy in place, and the establishment then of a new temporary shortage list, paragraph 73. One of the biggies, paragraph 81, was the end to overseas recruitment for social care visas. So close to new applications from abroad, and a transition period until 2028, where they're permitting visa extensions and in-country switching from those already in the country with working rights. There is a proposal in terms of the experience from the Displaced Talent Programme to have a limited pool of UNHCR recognised refugees and displaced people living overseas who have the opportunity to provide to apply directly for jobs and visas to come to the UK through a new displaced talent mobility scheme. But look, it's going to be an example they give is 10,000 places over 5 years. So it's very small and would not include a right to family reunion. Family reunion is something we'll come back to. The increase for the first time of the immigration skills charge, the draft legislation was introduced, and I think it came into force in mid-December in the end, bringing it up by 32%. Some positive announcements in paragraph 89. Some of those we've already seen come into force. It is the growth of very skilled routes, but again, a limited growth. So they say increasing the number of people arriving on our very high talent routes alongside faster routes for bringing people to the UK who have the right skills and experience to supercharge UK growth in strategic industries. So then increasing places for our research interns, so that's the government authorised exchange scheme, including those working in the field of AI to allow businesses access to additional promising young talent, making it simpler and easier for top scientific and design talent to use our global talent visa, review of the innovator founder visa to ensure that it supports entrepreneurial talent currently studying at UK universities to move into the visa. We've seen that happen, and I'll come back to that. Doubling the number of workers that overseas businesses can send to the UK with the aim of establishing a presence in the UK. That's the expansion worker, doubling from 5 to 10. And then a targeted and capped expansion of the high potential individual route. And we'll come back to that because we've seen that happen. Some tightening up in the regulation of student visas, and I've set those provisions out from the white paper, and of course strengthen requirements to show evidence that people are genuine students. And then another biggie, and we've already seen the date now set for this, the reduction of the graduate visa from 2 years to a period of 18 months, and also the proposal of a levy on higher education providers. Then we've seen announcements. The government don't like the Article 8 cases and all the cases being allowed on exceptional circumstances. So they want to legislate in relation to that. And they said at paragraph 148, before the end of this year, we will set out a new family policy. Now, if you're checking along in your head of what's come into force, you'll know this has not happened and did not happen. So it's still to come, even though they said it would happen by the end of 2025. But this new family policy, so I presume it's something like a new expanded Appendix FM that covers everybody, will cover all UK residents, including those who are British, settled on work routes or refugees seeking to bring family members to the UK, have clear relationship requirements, ensure those coming to the UK have an appropriate level of English language skills, and ensure that the family unit has sufficient money to support any migrants without relying on the taxpayer through reviewing and extending the financial requirements to other dependent routes. So what they said is, well, while this is undertaken, we've commissioned MAC, paragraph 149, to look at the financial requirements on family routes. And we know, and I'm not going to go through it today, that MAC reported in the summer in relation to the family routes and didn't really want to increase it above the 29,000. Their suggestions, they gave various suggestions, depending what metric you use to calculate it, were less than the 29,000. They've also said they'll explore tightening the suitability rules, where we know we've got now the new part suitability that has come into force. But let's get back to exceptional circumstances. They don't like the increase in the number of cases, paragraph 150, that have been allowed on exceptional circumstances grounds. So, paragraph 152, in order to ensure that Parliament sets the boundaries within our international obligations, we will set out a clear framework to be endorsed by Parliament for those seeking to enter or stay in the UK, including on the basis of exceptional circumstances who do not fall within our family policies. And they say this is going to set the fair balance. So they're going to try and limit claims by those who try and get around the rules by coming on short-term visit visas and then applying to stay on the basis of family relationships, those who try and frustrate and delay removal with spurious claims, trying to build up an Article 8 claim, or those who make immediate claims for wider family after arriving in the UK, including after making dangerous journeys. I think that's in terms of family reunion they're referring to there. So 156 refers to legislation. They're bringing forth legislation to strengthen the public interest test to make clear that Parliament needs to be able to control our country's border and take back control over who comes to and stays in the UK, striking the right balance between family rights and the wider public interest. Clarifying Article 8 rules and set out how they should apply in different immigration routes so fewer cases are treated as exceptional, and set out when and how a person who can genuinely make a claim on a basis of exceptional circumstances. Clearly, if you've got cases that don't neatly fall within the rules and you're relying on Article 8 or exceptional circumstances, I'd encourage you to get those applications in before these changes come into force. There's reference here to community sponsorship schemes. In terms of the sponsor license scheme, they talk about putting more responsibility and accountability on effective and responsible sponsors. And we've seen a huge uptake in enforcement action over the last year. This will include exploring making it easier for workers to move between licensed sponsors for the duration of their visa, giving them more control over who they work for and reducing the risk of exploitation. Then the sort of increase in enforcement action and the sort of compliant environment with working with HMRC, banks, etc. Then the announcements of the increase in relation to the English language, and we've seen that now come into force, and that's moving the requirement for skilled workers from B1 to B2. And then for the first time, introducing a new English language requirement for all adult dependents of workers and students. I'm in paragraph 255 at A1 to align with the spouse and the partner routes, and they'll consider increasing that over time. Progression in terms of extension, so progression to A2 and B2 for settlement, and moving to B2 for settlement across the board. Then this suggestion about, which we now have the consultation for, earned settlement. So moving the standard qualifying period for settlement to 10 years. They'll continue to offer a shorter pathway to settlement for non-UK dependents of British citizens to 5 years. Interesting there, they don't say partners of settled persons, but partners of British citizens. And then about reducing your period if you make contributions to the UK economy and society. And we'll go through the proposals and the consultation in a moment. In terms also of creating settlement, also creating a new bereaved partner route and protecting children who've been in the UK for some time, turn 18 and realise they don't have status. Also a move to sort of earn citizenship as well. They're flagging up here, and a refreshment of the life in the UK test. So that is a whistle-stop tour of the May White Paper. That shaped what was to come. Before we had any of those big changes come into force, they snuck out HC 836. This was kind of I always think this was the one with the positive changes before the later changes hit you. So quickly, HC 836 from June. There was a change to Appendix Long Residence to clarify that time spent as a British citizen is considered lawful presence, except where that British citizenship has subsequently been deprived. You might think, what? Why does British citizenship need to be considered lawful presence? Well, this relates to those who renounce their citizenship. So that's what that's in relation to. A change in relation to Appendix Continuous Residence, treating time in the Crown dependencies with leave on an equivalent route as lawful presence. A positive change in relation to Appendix Private Life. You might have seen a video I did on this in the past about the problem with the drafting of Appendix Private Life for those, say, young people applying for the early 5-year settlement, was that they had to last have permission on the private life route. That was problematic because some people were granted as Appendix FM dependents or outside of the rules. That's been clarified and changed now. So more favourable for children and young people applying for settlement after 5 years lawful residence there. Have a look at that. A change to the continuous qualifying period definition for the EUSS to simplify the assessment of continuous residence. These changes enable a pre-settled status holder to be granted settled status where they've been resident in the UK for at least 30 months in total in the most recent 60-month period. This can be any 30 months within that 60-month period. And then some changes to Part 9 of the rules in relation to mandatory cancellation or refusal for those subject to exclusion from asylum or humanitarian protection. That's been overtaken now by the new part suitability, which we'll come to in a moment, and some other minor changes to be aware of. So then we had one of the two big statement of changes this year, the two biggies that really brought in a lot of the white paper changes. The first one was in the summer. I'm sure those of you who deal with skilled workers probably had a very busy July as a result of this, but this was HC 997 from the 1st of July. So this is where we see significant changes to the skilled worker route from that day that's probably etched in everybody's memory now. You probably all need therapy as a result. The 22nd of July, 2025. That was where the skills threshold increased to RQF level 6. That doesn't mean you have to have a degree, but the job must be at that skills level. Removing, as I said, approximately 180 occupations from eligibility. There is that transitional protection for those existing visa holders or those with a COS issued before the 22nd of July. So that's set out there. There were also the higher salary thresholds that were brought in. I've only stuck some of them there in my slide, but the general salary increased from 38,700 to 41,700. Then we've got the PhD in a relevant subject going up to 37,500. The PhD STEM immigration shortage list or the salary list or the new entrant going up to 33,400, and no transitional provisions in relation to this. Now, I mentioned the Migration Advisory Committee. Have a look at Professor Brian Bell's letter to the Home Secretary of the 17th of December. But what they say is they do not recommend a change from 41,700. What they do is make recommendations in relation to the discount thresholds for certain groups. They recommend a single new entrant rate of 33,400 to ensure a typical graduate entrant can be recruited using the migration system. But they recommend abolishing the PhD discount. So have a look at those. Shortage lists. Well, the immigration salary list was set to be replaced by the temporary shortage list. But for now, we've got these two lists, both sort of time limited at the moment to the end of December this year. Then after that, a new temporary shortage list will exist to replace the immigration salary list. But for now, ironically, the immigration salary list has been expanded and we have this temporary shortage list. Note the restrictions on bringing dependents. The end to overseas care worker recruitment was introduced by HC 997. So no new entry clearance applications for care workers from the 22nd of July 2025. Care workers or senior care workers. In-country switching allowed up to 22nd of July 2028, provided there's been work for 3 months with the sponsor. And then this was where they got rid of that requirement to recruit from the pool of skilled workers seeking new sponsorship. So that which was brought in the March statement of changes was removed once they ended overseas care worker recruitment. There was also the closing again on 3 p.m. on that day to ARAP, the Afghan Relocations and Assistance Policy, to new principal Afghan applications. There were some provisions for family members of principal applicants who'd already submitted applications could still apply afterwards. We're getting through them. Let's get to August now. So we're in the heady days of summer, but the statement of changes, we couldn't just lie on the beach last summer. The statement of changes just kept on coming. So there's an extract here from the Journal of Immigration, Asylum and Nationality Law. But that sets out the background to the treaty between the UK and France being ratified on the 4th of August for then France to take back small boat arrivals. But as a result of that, this statement of changes was laid on the 5th of August to provide for some people to come over from France. So this is the Appendix UK European Applicant Transfer Scheme. So it operates for a time-limited application window, restricted to those in France, and it's a sort of two-stage with an expression of interest stage first. And I've set that out on the next slide about the expression of interest, and then those will be moved forward, and there's different categories for those who criteria of sort of prioritization for those who will be moved forward to the entry clearance stage. Then on the 4th of September, the Secretary of State announced the pausing or suspension of new applications under Appendix Family Reunion from 3 p.m. on that day, and an amendment to Appendix FM to allow for family reunion applications under Appendix FM. But of course, they'll be subject to a fee or a successful fee waiver, and then to English language and financial requirements. Obviously, family reunion is, for good reason, has always been treated differently. But their proposal is to bring in this new all-encompassing family sort of appendix. But until then, pausing of new applications under Appendix Family Reunion and people being forced into Appendix FM. Be interested to know what people are doing. When I've done training around the country, some people are just waiting to see what changes come in. If somebody's desperate, they're making sort of fee waiver applications under Appendix FM and then relying on things like Gen 3.2, maybe 3.3. Here's the written statement to Parliament that accompanied this suspension of new applications to the family reunion. And again, this talks about setting out the new family policy before the end of this year, but it didn't happen. So watch this space because that must be coming shortly. Then we had the second of the big statement of changes, and that was HC 1333 on the 14th of October last year. And I've set out a list there from the explanatory memorandum of all the different changes that this introduced. Now, I'm not going to go through them all in detail because you could fill an hour just going through them, but let's give you some highlights. So again, this time it's the term of Botswana. They're being added because of the number of asylum claims to the Visa National list. And again, comes in at 3 p.m. subject to the usual 6-week transition period. Because of the recognition of Palestine in September, formally recognised by the government, Palestine is now added to the Visa National list. That comes in from the 11th of November. There was also an introduction of dependents to be able to apply under Appendix statelessness. So partners and children of a stateless person could apply under Appendix statelessness, but that this related to those who were already partners or children before the person got their status. For those where the family unit was formed afterwards, they have to apply under Appendix FM, which is obviously more difficult. That came in from the 11th of November. Ironically, until the 11th of November, dependents could be considered under the old paragraph 410 and 411, which were more generous. I've put there just for an article, a helpful article, the asylum aid judgment and the web archive of the rules, the old rules, if that applies to anybody. Changes to the English language requirement for the economic migration routes. So from the 8th of January 2026, so this month now, these have come into force for new applicants under the skilled worker, high potential individual and scale up routes. So from B1 to B2, those on existing will stay at the B1 level. Look at paragraph 5.22 of the explanatory memorandum. What is B2 for those of you who don't know? It's upper intermediate level of English, where a person can understand the main ideas of complex text, produce clear and detailed writing, and interact with a degree of fluency and spontaneity with native speakers. Goodness, I don't know if I can do that. Then there was a targeted and capped expansion of the high potential individual. So an increase of the number of universities on the list. So remember, you have to have graduated in the last 5 years. You get, I think, is it 3 years under the, or 2 years, and then it's PhD 3 years for those under the high potential individual. It's quite, it doesn't work towards settlement, but quite a flexible visa. So something to consider for your client base. So it's not based on nationality, it's based on where you graduated from. So there's the university list set there, but something worth thinking about with your clients. And I've included a helpful article if you want to look at this and perhaps advertise this to your clients as an option. So here's the change to the graduate route. So this is not coming into force until 1st January next year, 2027. And that's the change to 18 months. But PhD graduates will remain at the 3 years. So 18 months from the 1st of January 2027, but doesn't apply to PhD graduates. Then this was the change that allowed students to transition to the innovator founder route. This was from the 25th of November 2025. I put a helpful article from Smithstone Walters there about that, but it allows, while the application is pending, student visa holders to establish their business. This might be helpful when we look at the settlement proposals, because I think when you're advising clients now, you need to have an eye on what the government's going to do with settlement. And some routes are much quicker to settlement. So that's something to have an eye on when advising, say, students going forward. Then we have part suitability. So 11th of November, part suitability comes into force, which is now the central reference point for all suitability related refusal and cancellation grounds. The famous paragraph 39E, the exception for overstayers, has now been moved and has its own section within part suitability. And now, where previously things like Appendix FM and the private life route had their own suitability requirements, they now are all subject to part suitability. So, for example, overstayers applying under Appendix FM didn't used to be subject to a re-entry ban. They now will be as a result of this. So, in part suitability, very significant change, and its interaction with things like Appendix FM. I'm doing, in a couple of weeks' time, a bespoke seminar on that. Some changes to the seasonal worker route, to permit seasonal workers to spend no more than 6 months working in the UK during any rolling 10-month period. Some positive changes in terms of Appendix Global Talent. Again, something worth looking at because of the nature of it and the ability to settle and the flexibility. But does your client really satisfy having the necessary talent to satisfy this route? But what's been increased is the number of prestigious prizes by 27. So those with a prestigious prize don't need the endorsement stage. One prize has been deleted because the prize is no longer awarded and there's nobody living who's ever won it. So yeah, that's been deleted. But some expansion in terms of the global talent route worth looking at with your clients. That was from the 11th of November 2025. Some uplifts to the students' maintenance requirement and changes to the continuous residence rules also came in on the 11th of November 2025. So some key dates just to summarise. Botswana was the 14th of October. 4th of November was the high potential individual route expansion. So that's something worth looking at with your clients. The big date was the 11th of November with part suitability, global talent, etc. 25th of November was those transitioning from the student route to the innovator founder route. Again, I've said that's worth looking at. That was that date I mentioned earlier. 16th of December, the immigration skills charge increased. English language came in 8th of this month, January 2026. And the one we're waiting for is the 1st of January 2027. So, restoring order and control, a statement on the government's asylum and returns policies. So, this is what we get on the 17th of November 2025. Quite significant, because refugees will no longer get 5 years under this proposal, but will get 30 months. And there will be, in the future, there will be no path to indefinite settled status in the UK on core protection until a refugee has spent 20 years in the country. So it's moving from 5 years to 20 years. But what they're proposing is that refugees can move from a core protection route to a in-country protection work and study route, upon which somebody can qualify quicker for settlement. And also, under core protection, no automatic family reunion, but those on the in-country protection work and study route may be able to sponsor then people, family members, to come to the United Kingdom. Changes in terms of criteria for the ability to have public funds or not to lose them. They're removing the legal obligation to provide support to asylum seekers who would be otherwise be destitute. I'm not going to comment on this. You can imagine they're going to deny support to those who have the right to work and can therefore support themselves. There's also proposals in relation to contribution to the cost of asylum support, where somebody has assets or income, but not enough to support themselves independently. They're committed to get everybody out of hotels by the end of this parliament, moving towards large sites, including military barracks, etc. I talked earlier about the increased enforcement. So anybody who does civil penalty or sponsor license work, you'll know that there's a huge growth in this area of work because of the uptick in enforcement, and the figures are there on the bottom of the slide. Increasing the right to work checks for those who are subcontracted or self-employed, including those in the gig economy. Talking about an introduction of the digital ID by the end of the parliament, but I did think that had been abandoned, so just do check up on that digital ID point. A continuation of the French returns pilot, we've looked at that in that statement of changes. Then resuming returns to certain countries, so they're going to see if somebody's still eligible for protection and has the country situation changed. The example they're giving here is the resumption of enforced returns to Syria. They're also talking about looking more to family returns and enforcing family returns, and having return hubs, which are safe third countries that failed asylum seekers can be returned to. They're also talking about visa penalties. So expanding returns agreements. They cite their return agreement with Iraq in August of last year and Vietnam in October of last year. And then this thing about visa penalties. So if you don't accept returns as a country, we won't accept entry clearance applications from your nationals. So a carrot and stick approach with visa penalties there. Then increasing capacity in the FTT. The Border Security and Asylum and Immigration Bill, well, it's now an act, has introduced the statutory timeline to come in for those in asylum accommodation and non-detained foreign offenders, but also this creation of a new appeals body with adjudicators. Now, there's been some details given by the Secretary of State that her letter is set out on the EIN website, so I'd encourage you to go to the news section of EIN, where more details is given by the Secretary of State. Acceleration of claims by those considered to have a low likelihood of success. Strengthening clearly without merit claims, and I think we've seen definitely an uptick in certification in 2025. Acceleration of appeals for removable high harm cases, foreign national offenders and others who are detained and readily removable. A single appeal. So that's interesting, because we know with new matters, the Home Office are often refusing permission for a new matter to be considered. But this is talking about everything considered in a single appeal. Expedited for late claims. You won't be able to rely on any further private or family life accrued after any appeal, other than in exceptional circumstances. Further submissions, they're cracking down on. And say somebody who's made a previous asylum claim, if they want to make further Article 8 submissions, rather than making just further submissions and not having to pay, they're going to want them to do proper Article 8 paid applications. Then to come back to what we talked about earlier, strengthening the public interest in Article 8, legislating to set out how Article 8 should be properly balanced. And they talk about defining family life. So that's what they propose to do, and it shouldn't go beyond immediate family members. We're going to see that the Court of Appeal have already made a significant decision in relation to this, defining how people can make Article 8 applications. And for those people who are abroad who want to join a family member in the UK, but they can't meet the rules, if they want to apply outside the rules, the application is going to have to be made in country by their family member. They want to look, we're totally against torture, they say, but we think inhuman and degrading treatment has gone too far, and we'd like to redefine that. So they're looking at what they do in terms of Article 3. They talk about the removal of reconsiderations in September 2025 in relation to NRM for ECAT countries and ECHR countries, and swift consideration of unmeritorious protection claims, also using AI for age assessment. And again, there's some proposal about what they propose to do in terms of safe and legal routes. So here's a summary. If you want to look at a summary, this just summarizes what is in Restoring Order and Control. Then finally, a fairer pathway to settlement. This is the third and final of the sort of policy papers I want to look at. So this is their proposals on earned settlement. This is open until 11:59 p.m. on the 12th of February. So you've got a couple of weeks to get your responses in. Really important. And the main takeaway is that they want to increase the standard qualifying residence period to 10 years. Some people will have reductions, including those in public services, those who volunteer. Obviously, partners of British citizens are not subject to consultation. Notice again, it says British citizens, not those who are settled. BNOs from Hong Kong are not subject to consultation. They stay at 5 years. Those who arrive illegally, not refugees, could take up to 30 years. So they say applicants must have a clean criminal record, must speak English to a high standard, must make sustained and measurable economic contribution. Finally, must have no debt to the country. The proposal with health and care visas is their qualifying period to go up to 15 years. So if you're a care worker, we value you so much, we want to make you wait for 15 years for settlement, which is absolutely crazy. Crucially, for these and every other group mentioned here, we propose to apply these changes to everyone in the country today who has not already received indefinite leave to remain. So you've got the residence pillar, and alongside the residence pillar, you've got the suitability pillar, clean criminal record, no debt to the UK. The integration pillar, which is B2 English, language, life in the UK. Suitability and integration, they're happening. They're not subject to consultation. The contribution pillar is, the proposal is that somebody needs to have earned above 12,570 for a minimum of 3 to 5 years. And then you've got these periods which can reduce that standard 10-year period, and you've got some things that can increase that standard 10-year period. So if you've got C1 English, you can take a year off. You can't aggregate these, by the way. You can only use one. If you've earned 125 grand, 140 for the last 3 years, you can knock 7 years off. Wow. If you've earned 50,270, you can knock 3 years off. Public service, you can knock 5 years off. Volunteering, we don't know exactly what that will look like 3 to 5 years. And then partner of British citizen or parent or child not subject to consultation, BNO not subject to consultation. And then global talent or innovator founder, 3 years, you can knock 7 years off. So you can qualify for settlement after 3 years. That's why I say consider the routes your clients are moving into. What about increasing your time? Public funds for less than 12 months can add 5 years. Public funds for over 12 months can add 10 years. Arrived illegally, you can add 20 years. Visit visa up to 20 years. Overstayed a permission for 6 months or more plus up to 20 years. Huge implications of this, do respond. Also, I was reading again today, within the paper, it talks about dependents and children and separating them from main applicants. So do have a look at that. Final statement of changes. December. HC 1491, Nauru has now gone on the Visa National List, this time because of their new citizenship by investment program. Some changes aligning cancellation and curtailment grounds on the EUSS, and some consequential changes as a result of the introduction of part suitability. Now, I've got about 13 minutes left to cover a load of case law. I've slimmed the case law down because I probably had about 3 hours worth of slides when I first designed this webinar. What I'm going to do is, looking at the time, give you some headlines. So let's have a look at family life. Chikwamba is pretty much dead. One of the early cases from this year is the case of Butt, and Lady Justice Elizabeth Lang confirmed that what Alarm decided is that Chikwamba is only potentially relevant now if the Secretary of State is saying you must go back and apply for entry clearance. And even then, it's not a silver bullet, but must be part of the overall proportionality assessment. What about family life and precariousness? Well, again, Lady Justice Elizabeth Lang, case of Arshad, uncle or brother living with his sister, and he was uncle to her 3 children, but she had her husband living in the house, so he wasn't acting as a parent to the kids. So what's said here is, just because something equals family life, it doesn't, all family life is not the same. The fact finder needs to address the particular weight to be given to that family life. So remember, when you're arguing cases, to set out the particular strength of the family life, because not all family life is equal. And similarly, there's a range of precariousness. So when they're weighing the balance, make sure you deal with these points in terms of how precarious has my client been, what is the exact nature of the family life, and the weight should be given in the public interest balance. IA Gaza is a significant case on family life and adults, in this case, adult siblings. And this is what I've said, where we've seen the proposals in the government's paper of wanting to define a narrow family life. The Court of Appeal have sort of doubled down and reiterated the dependency test that is needed, that additional element of dependency involving more than the normal emotional ties, to establish Article 8. What the upper tribunal had done had applied the test of the real existence of close personal ties, but they hadn't properly applied the dependency test. So real and effective committed support is not enough. It's that dependency that's required. Once you establish family life, it is the unitary nature of family life that is considered, as per Bioku Betts, but the focus is through the person in the UK, namely the sponsor. Have a look at the other criticisms of the upper tribunal and their approach to Article 8 in this important case. And really, I think, sets the direction of travel, given what's been said in those government policy papers as well. Often you might find yourself arguing a case under Appendix FM under Gen 3.1, 3.2 or 3.3. Gen 3.1 allows for alternative sources of income. Gen 3.2 is then the unjustifiably harsh provision, and you have the could and the would wording. Could in 3.1, would in Gen 3.2. Lord Justice Green sets out the test there in Kira, and it's well worth looking through that. I've highlighted the key sections for it. And when it talks about the use of the word are, it means that circumstances must be extant, and you can't rely on hypothetical circumstances. But that use of the word could means a realistic possibility. So that's more than just a mere theoretical possibility. Very recent case, 17th of December, so I haven't written it up, but I've just put the extracts for the judgment, is Cone, which is on 2971F. This is where somebody's applying where one parent is settled and the other parent had limited leave. The Home Office are trying to say you can't rely on 2971F in those circumstances. The Court of Appeal disagreed. So if you're trying to rely on 2971F to bring a child in where one parent is present and settled and the other parent has limited leave. Have a look at that. Sponsor license cases. Well, I've just narrowed it down to 2 today. I talked about care workers earlier, and we've seen a lot of the sponsor license revocation cases involving care homes. 2 cases combined, Prestwick and Supporting Care, went to the Court of Appeal. The first question was on whether there needed to be a global assessment before revoking a sponsor license. In the Court of Appeal, Prestwick said they didn't need to be a global assessment, and they followed the test set out in the One Trees Estates judgment. But in Supporting Care, whilst the judge had been wrong about the global assessment, the Court of Appeal upheld the quashing of the decision on procedural fairness grounds because Balajigari principles had applied and they hadn't been followed. So Balajigari principles important. And this is what was looked at in Prestige Social Care Services Limited by His Honour Judge Tyndall, about this whole idea of a genuine role or a genuine vacancy, and when the Secretary of State had to show dishonesty or what he calls other reprehensible conduct. And there'd been sort of conflicting authority in relation to this. What he says is, well, where the Secretary of State relies on ground Z or paragraphs C1.46 to 47 of the sponsor guidance, they do need dishonesty or some other reprehensible conduct, and Balajigari principles apply. But the Secretary of State can say something's not a genuine vacancy without alleging dishonesty. In certain circumstances, look at Roman 4. But even there, basic public law principles of procedural fairness apply. It's fairness I want to turn to next, and I want to take us down the road from where I am now and Birmingham New Street Station. That was the case of Ahmed and the Secretary of State and this random enforcement operation at Birmingham New Street, where poor Mr. Ahmed was picked up. He was interviewed in the presence of everybody at Birmingham New Street without an interpreter. He'd appeared nervous and walked away from the officers. His Honour Judge Simon found the judgment was confined to the very specific circumstances of the case, but found that the case succeeded on procedural fairness grounds. And there's a helpful summary, both of the legislation and the policy guidance in relation to procedural fairness and enforcement interviews. But also, it's really interesting to look at the factors the judge took into account in finding that there was a lack of procedural fairness. 2 other cases I've highlighted in the notes: Singaram, which was unsuccessful, but Core, which was successful. That was somebody whose leave to remain was cancelled using a Red 1 notice. The Deputy Judge was very critical of the decision making in this case and the way the Secretary of State had conducted the litigation. So that's well worth a look at if you're challenging something on fairness grounds in terms of the cancellation of permission. Just 2 protection cases to highlight to you. I've talked about PG in previous webinars, but this is when you're trying to depart from a country guidance case. Obviously, to depart from a country guidance case, very strong grounds supported by cogent evidence needs to be shown. You don't just need to rely on new evidence, but you've got to engage with the material which was before the tribunal which made the country guidance case, and that's what hadn't been done by the upper tribunal in this case. I know a lot of our clients in protection cases at the moment are involved in both surplus activities, demonstrations, but also in Facebook activities. And the Court of Appeal in MH Bangladesh gave some helpful guidance on sort of monitoring by the home state and the type of evidence that the court would expect, and not to be unrealistic because somebody's not going to have direct evidence of covert surveillance. So MH Bangladesh is worth looking at if you've got one of those cases. In terms of judicial review, Jimmo, helpful decision by Ms. Justice Obi. He was on the pre-2012 discretionary leave policy. For those who remember it, it was 3 years plus 3 years. Then after 6 years, you could apply for indefinite leave to remain. He was refused, ultimately relying on a conviction, a very old conviction. He also had referred to the medical claims policy because he had serious medical conditions. The Secretary of State's decision was quashed in this case because of their reliance on that conviction, which predated his grants of discretionary leave, and their conflation of the rules-based mandatory refusal approach to this pre-2012 DL scheme, which had its own sort of framework in the policy, that the decision was also quashed on the approach to the medical claims policy and to Section 55, so worth a look at. Al-Noor, well, we often want to say there's been no anxious scrutiny in a case. Al-Noor, Mr. Justice Fordham, in his characteristic way, very clearly sets out what is anxious scrutiny. So rather than just chuck in anxious scrutiny, have a look at Al-Noor, which puts some meat on the bones of what anxious scrutiny is. Hippolyte is a helpful case where somebody was applying under the Windrush scheme, couldn't satisfy the continuous residence, wanted the Secretary of State to use their discretion to waive. Ultimately, the Court of Appeal found it successful because the Administrative Court had found the Secretary of State had fettered their discretion, but refused to grant leave, finding they were under the Senior Courts Act, it would be highly likely that they would lead to the same result. Lord Justice Singh quashed that and made some helpful comments about the way the respondent exercises her discretion in a holistic way, remembering there's a real human being there at the centre of this. So some helpful stuff on discretion there. Dandapani is about a student who hadn't received a notice by email. Successful decision there in the Court of Appeal. They also confirmed the upper tribunal was wrong, that time for judicial runs, it doesn't start to run until an individual has been given the notice in writing, so time hadn't started to run, so the upper tribunal were wrong to find something was out of time. I'm not going to really look at EUSS because I've got 2 minutes left, but you've got there something about Zambrano. Borges is about trying to rely on the highest level imperative grounds of public security. You can't aggregate your time as a third country national and an EU. You've got to have 10 years as an EU national there. The horribly drafted definition of durable partners in Appendix EU is considered in Mustai or Mustaj. Have a look at that and the meaning of the famous paragraph AAA. They even correct the revised definition. So have a look at that. Please be careful using artificial intelligence. The court are hauling people up. MS is an example of somebody who relied on AI and then wasn't honest with the tribunal and it hallucinated false citations. It is your responsibility to make sure things are correct. False citations will lead to you being reported to your regulator. And if you deliberately have put false citations in, you're likely to be prosecuted. So yeah, that is so important. This case hasn't been reported yet about withdrawing to grant, creating a substantive legitimate expectation. This is when that happened at an appeal here in Birmingham, but the Secretary of State tried to subsequently change their mind, I think due to the publicity that the solicitor had posted on social media. HI, have a look at the creation of a substantive legitimate expectation when the Home Office withdraw with the view to grant subject to security checks. There's a really helpful free movement article. In terms of deprivation of citizenship, we've seen a number of cases. The correct approach to appeals is now summarised by the upper tribunal in the Lachi case. That follows the Court of Appeal's judgment in Chowdhury. The basic takeaway is that we're not now looking at the old sort of approach of a judicial review approach, but the precedent fact needs to be decided by the tribunal and all the evidence, including new evidence. How we deal with children's best interests is set out in Mujai. And then we've recently seen the Supreme Court in the Kolokai case confirm that an appeal on deprivation is an appeal on the merits. The interesting what Lord Sales held in relation to the substantive issues, in relation to discretion, etc. This case in relation to evidential flexibility and the admission of additional evidence on administrative review, Ganesamurthy is really helpful. Well worth looking at this if you're trying to rely on evidential flexibility, and Judge Blundell sets out how that has widened and the admission of additional evidence. Just finally then, De Silva Pino, if you've got different immigration decisions with different rights of appeal, lodge an appeal against each one. That didn't happen in this case. A judge tried to helpfully deal with it all together, but that was then overturned by the upper tribunal. I don't want to finish and make your head hurt, but if you're dealing with new matters, this case of Ajmalan, who is helpful. This is in the context of EUSS. It overrules the previous case of Ayula. For the Secretary of State to have previously considered a matter, they've had to give it deliberate thought. But it also says that a wide construction of the phrase relevant to the substance of decision should be given, and Chelik is preferred over Danny. So it should allow you to argue human rights new matters in EUSS cases, subject to the Secretary of State granting permission, because of course these are new matters and the Secretary of State needs to give permission. It is 2 minutes over. I do apologise. Thank you so much for everybody's attention. Sorry to go super fast today. Do download the resources, and then if you've got questions or want to take this further, come to one of my live events where we can look at that. Finn, back to you.
Thank you so much, Adam, and thank you to everyone for joining us today. Apologies for running out of time to answer any questions you may have had. As a reminder, the slides and a recording of the webinar will be available tomorrow. This afternoon, you should receive an email asking you to rate the webinar out of 5 stars. If you have enjoyed it, please do leave any feedback and any suggestions for future topics. Our series of webinars continues next week on Wednesday, the 4th of February from 1 to 2 p.m, when we will be presenting our webinar on judicial review and refusal of naturalisation on good character grounds, part 2, with Eric Fripp and Amy Childs from 36 Group. Thank you again for watching and have a good afternoon.
Thanks, everyone.
Cheers, Adam. Bye-bye.